Rely upon 2011-5 SSC on the question of, my lord, the precedent. Which could be precedent and what could be the... বলো
What happened?
I don't know. No, I don't know. Item number 12, Lordship, I was told that matter will be taken up now.
12.
I apologize. My instructions are not my lord because it has come from your lordship. When I was supposed to take it. That CPI is supposed to produce the sheet of the candidate concerned, as well as we have an answer string also. Under those circumstances, maybe comes for you to go with that because the
Answer string.
answer
What is that?
OMR sheet is the same cropped OMR sheet which is being produced by the commission. However, from there, the candidate will not be in a position to decipher as to what marks he has obtained. However, answer string is, I have just learned the phrase now. Is the number of answers he has attempted and the marks which he is working. So from there, he can decipher as to what is the marks he got. And from there, it will be clear whether he was successful.
Whatever is required to be.
Give to your lordship and let me open to my lord. I follow that way.
Yes.
On Monday. And others candidate they give, but for this candidate they not give.
They'll give.
Yes. I'm grateful.
Yes.
the 2011 volume 5 SSC.
Is it there in the compilation?
Yes. It's a brother.
11-5 SCC.
8708.
Page number 7.
Yes.
They will kindly come to paragraph 32.
Page what? Page what?
7.
Yes.
The paragraph 32, it needs a little emphasis that even one additional or different fact may make a world of difference between the conclusions in two cases, and blindly placing reliance on a decision is never proper. It is tried that while applying ratio, the court may not pick out a word or sentence from the judgment divorced from the context in which the said question arose for consideration. In this regard, the following words of Lord Denning quoted in so-and-so, but I am not reading the quotation. Now, this is the principle, my lord, which is accepted at Supreme Court. Therefore, the judgment of the division bench in a case where the issue was whether 2016 or 2025 would have no application as a matter of precedence. But this is one other, I'm not in respect of the schedule to rules, what would be constitutional, my lord, implication? 2011 7 SCC, page 789. Here in the schedule that additional 10 marks was incorporated.
Yes.
The paragraph 16 is the background of the facts. The procedure for direct recruitment is dealt with in part 4 of the rules, which requires inviting of applications, scrutiny of applications, recommendations of the commission, disqualification for appointment, and selection by the appointing authority. Part 5 of the rules deals with the procedure for recruitment by promotion, with which we are primarily concerned. I'll not be troubling my lord with that for a long. Then kindly come to my lord paragraph 28. Rule 24(6) of the Rules 79 mandates that selection for promotion to all other higher posts or higher categories of posts in the service shall be made on the basis of merit and on the basis of seniority cum merit in the proportion of 50-50. In other words, 50% vacancies are to be filled up on the basis of merit, while remaining 50% in the promotion quota are to be filled up by seniority cum merit. The persons have to be within the appropriate position in the seniority list before they can be considered for promotion under the later category. Eligibility requirements have been specified under rules which candidates must satisfy to be considered under the seniority cum merit category. The other persons who are to be promoted to the post of DTO are on the basis of merit alone. Even if Schedule 2 of the rules does not exist, it is obligatory on the part of the respondent to evolve a methodology to make promotions purely on merit. Once the framers of the rules have intended to provide merit as the sole criteria of promotion, the appointing authority is not vested with the jurisdiction to waive the same or completely wipe out the same on a flimsy excuse such as one proposed in the present case. In the light of this, we now come to conduct the government, which we cannot but help to comment upon. Right from so and so, no examination has been conducted by the appropriate authority, despite the fact that they also issued notifications for holding exams on few of these occasions. If there was a representation from the Transport Inspectors Union, it cannot be considered as a sufficient cause or reason for not holding the examination for more than 10 years and causing serious prejudice to the candidates who might have been sufficiently meritorious to qualify in the exam and be considered for promotion to 50% of the post under the promotion quota. It is a matter of regret that the government can take such a stand before a court of law and expect the court to accept such a submission. It is expressly untenable. Once the rules stand clear, the authority concerned is expected to act in accordance with the law and not default the law. One who defeats the law by his unjustifiable, unjustifiable act is liable for the consequences of default. Now here, therefore, the schedule really destroys the principal rule that it must be on the merit and the selection method. Therefore, the schedule cannot be contrary to the statutory rules. This is the principle. Now, I come to the point that the persons whose selections have been declared null and void by the Supreme Court, they are untainted. They cannot get benefit Supreme Court judgment in another matter. This is 2003 Volume 2 Supreme Court Cases, page 673.
Entry 30. Page number 467.
467.
67 to 467. 737.
Yes.
Now, we'll kindly come to paragraph 2, the facts, which is quite relevant for the purpose of similar consideration. In the past also, allotments of retail outlets for petroleum products were cancelled by this court.
Which paragraph are you referring?
Paragraph 2.
All right, 2.
May I read once again? In the past also, allotments of retail outlets for petroleum products were cancelled by this court after coming to the conclusion that the allotments made were arbitrary on account of political connections, motivations, and extraneous consideration. The tainted allotments were also cancelled by various orders of the High Court of Delhi. The allotments which are on merits and not tainted were not ordered to be cancelled. It's a matter of coincidence that exactly 7 years ago, on the front page of Indian Express, a news item appeared regarding the grant of retail outlets for petrol pumps on account of political and other connections. Now, in August 2002, i.e. exactly 7 years later, again a news item appeared on the front page of the same newspaper about allotments to the near and dear ones of the political functions, attributing the same on account of political considerations. In common case, The court observed that for these allotments, a transparent and objective procedure has to be evolved based on reason, fair play, and non-arbitrariness. Now, this is the background. And now kindly turn to, my lord, the relevant portions, paragraph 27 and 35. Paragraph 27.
Yes.
Article 14 guarantees to everyone equality before law. Unequals cannot be clubbed. The proposition is well settled and does not require reference to any precedent, though many decisions were cited. Likewise, an arbitrary exercise of executive power deserves to be quashed. Is a proposition which again does not require support of any precedent. It is equally well settled that an order passed without application of mind deserves to be annulled, being an arbitrary exercise of power. At the same time, we have no difficulty in accepting the proposition urged on behalf of the government that if two views are possible and government takes one of it, it would not be amenable to judicial review on the ground that the other view, according to the court, is a better view. Then we'll kindly turn to paragraph 35, 36. From that paragraph 34. In the case in hand, that paragraph 34. The only reason for the Amas cancellation was that a controversy had been raised. There was no application of mind to any case. Admittedly, none of the cases was examined. In Silekha Vidyarthi, this court held that arbitrariness is writ large on the impugned circular. In state action, public interest has to be prime guiding consideration. In Silekha Vidyarthi case, it was held that the impugned state action was taken with only one object, in view, that is to terminate all existing appointments irrespective of the subsistence or expiry of the tenure or sustainability of the existing incumbents, and that by one omnibus order, the appointments of government council in the state were terminated. It was also noticed that no common reason applicable to all of them justifying their termination in one stroke or a reasonable ground had been shown. The position is similar in the present case. The expression public interest or probity in governance cannot be put in straitjacket. Public interest takes into its fold several factors. There cannot be any hard fast rule to determine what is public interest. The circumstances in each case would determine whether the government action was taken in public interest or was taken to uphold probity in governance. The role model for governance and decision taken thereof should manifestly equity, fair play, and justice. The cardinal principle of governance in a civilized society based on rule of law not only has to base on transparency, but must create an impression that the decision making was motivated on the consideration of probity. The government has to rise above the nexus of vested interest, nepotism, and askew window dressing. The act of governance has to withstand the test of judiciousness and impartiality and avoid arbitrary or capricious action. Therefore, the principle of governance has to be tested on the touchstone of justice, equity, and fair play. And if the decision is not based on justice, equity, and fair play, and has taken into consideration other matters, though on the face of it, the decision may look legitimate, but as a matter of fact, the reasons are not based on values, but to achieve popular accolade, the decision cannot be allowed to operate. But after having learned the declaration from the highest court, which is again repeated by the court in last order, our order is final, that all these appointments are void. You are trying to give them appointment. Here, my lord, that's where paragraph 2 is placed. Some allotments were cancelled. You again wanted to bring them back to a different way. And that's this, my lord, Supreme Court says this is against. I'm tempted to not repeat this. The government has to rise above the nexus of vested interest and nepotism and askew window dressing. This was an attempt to window dress. The act of governance has to withstand the test of judiciousness and impartiality and avoid arbitrary or capricious actions. Therefore, the principle of governance has to be tested on touchstone of justice, equity, and fair play. If the decision is not based on justice, equity, and fair play, has to take into consideration other matters. Though on the face of it, the decision may look legitimate. But as a matter of fact, the reasons are not based on values, but to achieve popular accolade. Now, I am constrained to not make reference, Archie, that after the Supreme Court judgment, the highest governing authority said, I don't bother about Supreme Court judgment. I have methods to see that these peoples are taken back to the job. We can't simply ignore this. They are the public will. And court must take judicial notice of this fact. That's to accord the public accolade, if you say so, after having the judgment of Supreme Court, this is bad. And Supreme Court re-emphasizes on the last day, when all attempts are made to see that these appointments which are sought to be made are not interfered with by different applicants. And the next is, paragraph 45. The solution by reasoning to cancellation of all, the solution by resorting to cancellation of all was worse than the problem. Cure was worse than the disease. Equal treatment to unequals is nothing but inequality. To put both categories, tainted and the rest, on a par is wholly unjustified, arbitrary, unconstitutional, being violated of Article 14 of the Constitution. It is apparent from the guidelines that the dealership and distributorship were provided to be given to the allottees as a welfare measure. Even in respect of open category, there's a limitation for the income, so and so, but that is in the fact of the case. Therefore, once they were cancelled, paragraph 2 have started, they are tainted. They cannot be put at par with the persons like freshers. And you wanted to bring them, giving the additional 10 points. These are all not in consonance with the constitutional governance. সবগুলো দেখার দরকার নেই, আমি জাস্ট I will just refer to the part of judicial review for the rules are concerned. 2024 volume 13 SCC 1. But I am not piling up with the judgment on the same point. I'm just giving the relevant points. Page 1.
Entry number 9.6.
9C1. Page number 230. Only one.
Paragraph 105, state way I am taking to lordship without placing the other paragraphs where deals with the constitutional authority in detail. I am not placing it. Therefore, I straightway come to the conclusion, paragraph 105. I got it.
Not yet. Which page do I get that?
Page 52 of the judgment.
Page 52 of the judgment.
Page 9.3.
Paragraph 105, Lordship got it?
Which page in the compilation will it be?
Start from page number 230.
I got that, but paragraph 105.
Paragraph 105. No, that means
346.
346.
Paragraph.
Oh.
The state of HP, the Associated Democratic দিচ্ছ কেন? ভুল জাজমেন্ট দিয়েছো। ভুল জাজমেন্ট।
What is the cost title?
The state of Himachal Pradesh versus Jogendra Mohan Shetty. 24-13 5 পেলে। No. 24-13 SSC page 1. এই যশোরকে দাও বইটা।
Give the citation, it is
2014, 2024,
2024.
volume 13, Supreme Court cases,
Yes.
page 1.
All right.
State of Himachal Pradesh versus Yagendra Mohan Sengupta.
All right.
The judgment of the just the retired Chief Justice. I'm just read out loudly.
Yes.
It could thus be clearly seen that this court, even when a provision in the Constitution enabled Parliament to make a law, thereby excluding the powers of judicial review, except under Article 136 of the Constitution, held that the power of judicial review vested in the High Courts under Article 226. And this court under Article 32 of the Constitution is an integral and essential feature of the Constitution, constituting part of its basic structure, and therefore the power of High Courts and this court to test the constitutional validity of legislation can never be ousted or excluded. This court further goes on to observe the power vested in the High Courts to exercise judicial superintendence over the decisions of all courts and tribunals within their respective jurisdiction, also a part of the basic structure. And always a point is sought to be taken that this judicial review is beyond the purview of going to the policy decision. Yeah, this is good. No. This is the basic structure of the Constitution. Though the Constitution enabled Supreme Court only under 136, this court says no, this power is vested with the High Court under Article 226 also. Therefore, this court not has a power to interfere. And while we are summing up on these points, another important judgment I feel is necessary. But once a statute was declared virus by the Supreme Court, but subsequently again, when the matter went up to the Supreme Court declared that ultra virus. Supreme Court, it is permissible. This is a constitution, is a dynamic document. AI 1986 Supreme Court.
Page number 1.
I'm sure the many voices would come that the justice so mentioned in division decided so and so, therefore you can't do this. Though according to me, Justice Shane Millett had no occasion to deal with this. But this is AI 1986 Supreme Court 1444. This is corresponding to 1986 volume 3 SSC, page 385. These principles have been reiterated later also, that I have not brought those judgments just to show that this is the basic judgment. Joshua, SSC দিয়েছো?
এখান থেকে করবেন প্যারাগ্রাফটা ট্যালি করবেন
না আমি বলছি বাইরে এখান থেকে Not the paragraph 4 I shall rely upon. The paragraph begins with this counter affidavit. The counter affidavit does not explain why any distinction should be made between residential and non-residential buildings in the matter of affording the protection of provisions of the Act. To say that non-residential building is different from a residential building is merely to say what is self-evident and means nothing. Tenants of both kinds of buildings equally need the protection of the beneficent provisions of the Act. No attempt has been made to show that the tenants and non-residential buildings are in a disadvantageous position as compared with tenants of residential buildings, and therefore they need greater protection. There is and there can be no whisper to the effect. To illustrate by analogy, it is not enough to say that men and women are different and therefore they need not be paid equal wages even if they do equal work. The counter affidavit has repeatedly referred to the weaker sections of the people and stated that in order to protect the weaker sections of the people, a distinction has been made between so and so. It is difficult to understand how the exclusion of tenants who pay higher rent from the protection afforded by the Act will help to protect tenants belonging to the weaker sections of the community. It is one thing to say that tenants belonging to the weaker sections of the community need protection, and altogether different things to say that the denial of protection to tenants paying higher rents will protect the weaker sections of the society. Further, the distinction suggested in the counter appears to be quite antipathic to the actual provision because, as we pointed out earlier, there is no such ceiling in the case of tenants and non-residential buildings. Therefore, a tenant of non-residential building who is, I just skip over the facts, and then we must also observe here that whatever justification there have been in 73, when section 30 was amended by imposing a ceiling on rent payable by tenants to residential buildings to entitle them to seek a protection of the act, the passage of time has made the ceiling utterly unreal. We are entitled to take judicial notice of the enormous multifold increase of rents throughout this country, particularly in urban areas. It is common knowledge today that the accommodation which one could possibly got in 1973 will today cost at least 5 times more. In these days, the universal day-to-day escalation of rentals, any ceiling such as so-and-so is totally artificial. As held by this court in such and such, a provision which was perfectly valid at the commencement of the Act could be challenged later on the ground of unconstitutionality and struck down on that basis. What was once a perfectly valid legislation may, in course of time, become discriminatory and liable to challenge on the ground of its being violative of Article 14. After referring to some of the earlier cases, Venkataramaya observed, the garb of constitutionality which it may have possessed earlier has become worn out, and its unconstitutionality is now brought out to a successful challenge. Therefore, if I may proceed, this is my duty. Sri So-and-so and Council for Tamil Nadu invited attention to some sentences from So-and-so, where referring to section 30, before it was amended in 73, it was observed, clause II exempts any residential building or part thereof occupied by any tenant if the monthly rent paid by him exceeds so-and-so. Hence, the object of legislature clearly was that the protection of the beneficent provisions of the Act should be available only to small tenants, as they belong to the weaker section of the community and really need protection against exploitation by rapacious landlords. Those who can afford to pay higher rent would ordinarily be well-to-do people and they would not be so much in it so-and-so. These observations were made in 74, soon after the amendment of Act in 73. They were made in a different context and not in the context of a challenge to the vagaries of the provisions as violative of Article 14. As we pointed out earlier, the argument based on protection of the weaker section of the community is entirely inconsistent with the protection given to tenants of non-residential buildings who are in a position to pay much higher rents. We are therefore satisfied that Section 32 be struck down as violative, which was earlier declared valid, now declared valid. Therefore, the Constitution is a dynamic document. It requires interpretation from time to time with the change of society and development. And again, in this case, conscience would prick. Judicial conscience, of course. The large scale of corruption, the entire selection having been set aside, an attempt was made to bring them back through back door. We, the freshers, cannot be equated with the persons who are found to be tainted and given the same door to entry, and that to giving an additional advantage. That's why this is unconscionable. These are my points, Milord. No, Milord, anyway, this is not required even then. That if the government, Milord, wants that the selection had proceeded, let it proceed, Milord, without this 10 marks benefit. Let them be brought on the same level and let them be adjudged on merit. Let us see, Milord, who is found to be meritorious. The ultimate purpose is to choose the meritorious person for the purpose of teaching, and that merit must be on the basis of, Milord, the entry door eligibility. Nothing from back door. Now, these are my submissions.
So, would you restrict your submission or the challenge primarily to the 10 marks? If this 10 marks goes,
the rules makes eligibility clause as the entry point. That should be treated as a level playing field all throughout. These additional 10 marks, the percentage of merit could be, as you have seen, on the basis of the marks of 10. 60% you get higher marks, 30%.
This I understand, but this will be one set of candidates regarding the 10 marks. There is another set where the eligibility marks 60% or 45 or something has.
That has been made. Look, my challenge is all throughout. But confusion create karo. My challenge is all throughout. First, let the entire rule should be declared ultra vires. But
Yes.
these are not in consonance with the standard
Supreme Court
practice.
judgment
And the
also.
Supreme Court is not judgment also. But not if an appeal is made, let there be some workable solution. It may also happen. Then the workable solution can only be made without awarding 10 marks, which is an additional boost. Though they are not entitled to participate.
Right. What will happen to those candidates who could not participate in the recruitment process because of the alteration of the
That's why
marks?
after this is declared, I said the first point, because I didn't think it should go. There should be a clean slate. It should be completely de novo. That is my first plank of argument. These are alternative arguments, depending on the situation and the
I would like to hear the other petitioners also.
Because these 2016 candidates, are not entitled to participate. That's my first point. In view of the Supreme Court judgment. None is entitled to get without any benefit because their appointments are void.
No, at the same time, the court directs for conducting a separate recruitment process for them.
For the vacancies.
Yes.
Which was available then.
Right.
If you had undertaken the exercise of filling up 2016 vacancies, there was no difficulty because the candidates who had appeared all at the same point, they would have been contested. Now you have created this trouble. Now,
what was the declared vacancy in 2016?
Not in 2016, declared vacancy was
around 12,000 and 5,000.
Vacancy
12,910, 12,915 or 5,700 something.
Yes, 12,500. I think that's available. The state can also.
All right. And in 2025, the vacancy has increased.
1,000. In 2016, the vacancy, please to note it down. 2016, it was 12,905. So for 910. In 2025, it is 23,212.
Classes 9 and 10?
9 and 10.
All right.
And then for recruitment to class 11, 12, 2016, it was 5,712. And in 25, it is 12,514. But I am not troubling now Group C and Group D. That will.
No, that is not.
And I am told this is mentioned in the reputation.
All right.
Paragraph 8.
All right.
Paragraph 93. Paragraph.
কোথাও বাড়ি তোমার কিছু ঠিক মতো পড়ো না Supreme Court judgment. I'm just not at the risk of repetition, reading out the Supreme Court judgment. প্রথম যেটা টেস্ট করেছিলাম কোন প্যারাগ্রাফে কেন কিছু যখন আর্গু করি মাথা থাকে ডিভিশন বেঞ্চ চাইছি না আমি সুপ্রিম কোর্ট চাই প্যারাগ্রাফ 20 Paragraph 19, my lord, the following principles emerge from the aforesaid discussion. Supreme Court.
Paragraph 19 of the Supreme Court judgment.
Yes.
All right.
Page 76.
All right.
When an in-depth factual inquiry reveals systematic irregularities, such as malice or fraud that undermine the integrity of the entire selection process. Lord, I have been repeatedly trying to highlight this. The result should be cancelled in its entirety. However, if when possible, segregation of tainted and untainted candidates should be done in consonance with fairness, equity, the decision to cancel the selection en masse must be based on the satisfaction derived from sufficient material collected through a fair and thorough investigation. It is not necessary for the material collected to conclusively prove malpractice beyond a reasonable doubt. The standard of evidence should be reasonable, certainty of systematic malice, the probability test applicable. Despite the inconvenience caused to untainted candidates when broad and deep manipulation selection was proven, due weightage has to be given to maintaining the purity of the selection process. Individual notice hearing may not be necessary. This is the legal finding, and then, in our opinion, this is a case where the entire selection process has been vitiated and tainted beyond resolution. But what is the impact of this? Manipulations and frauds on a large scale, coupled with attempted cover-up, have dented the selection process beyond repair and partial redemption. The credibility and legitimacy of the selection are denuded. The High Court has referred the illegalities. I am not troubling my lot with that. In this background, now the directions come at conclusion. Paragraph 45. After having those legal findings, now the question comes to the Supreme Court for relief. And while relief may not, the Supreme Court has exercised the power of Article 142 also in few cases. I should leave that. The asked questions relates to the relief and whether it requires any modification. We find no valid ground or reason to interfere with the direction of the High Court that the services of tainted candidates were appointed must be terminated and they should be required to refund salaries, payments, and so. Their appointments were the result of fraud. This amounts to cheating. Therefore, we see no justification to alter this direction. First, so for the tainted categories list have not yet been published. Supreme Court has directed this court to ensure the list is published. Nobody slips in. Then for candidates not specifically found to be tainted, the entire selection process has been rightly declared null and void due to egregious violations of illegalities which violated Article 14 and 16. But if the selection is set aside on the ground of violation of the constitutional provision, the constitutional body cannot take a turn around and say we'll throw them back door. Therefore, these people also does not have any right. That's why I had cited the judgment of petroleum dealers, which was once set at naught. The Supreme Court said you cannot bring them back and put it at the same plane that of the untainted people. Therefore, this is the position, my lord. I would therefore appeal your lordship, my lord, can you consider the entire aspect and ensure that the selection process for teachers are made, my lord, absolutely beyond reasonable doubt to instill confidence in the minds of the, my lord, the society, which is much more important than any other thing. Deeply honest.
The other petitioners.
I was appearing in item 27.
No.
27?
Judgment.
Which item?
Disabled.
49 disabled.
না পড়ে বল না পড়ে কেন আমি বলেছি দেখেছি সব আর্গুমেন্ট হয়ে গেছে এখন লিস্ট বার করুন এটাই তো হচ্ছে টেন্টেড লিস্টগুলোটা really I've prompted to make this submission, that unless the tainted list, the tainted categories have been defined by the High Court, they must come out honestly with that list. There are appointees who got appointment after expiry of panel. That is also under the tainted groups.
I have passed an order
Yeah, you have passed an order.
Yesterday.
yesterday.
ডাইরেকশন থাকা সত্ত্বেও
এটা তো ডিরেকশন আছে প্রকাশ
না
করা।
না 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 সেটা ডিরেকশন থাকা সত্ত্বেও করেনি।
Has that order been uploaded? Not yet.
No, no. Yesterday's order not uploaded.
Order. Alright.
Yeah, but
It's uploaded. Yes, only the list to be, their names should be.
Now, the division bench judgment was upheld in toto. There was direction that OMR sheets available in the third hard disk, if not already done, such portion not done must be uploaded in the website of SSC forthwith. But that is also necessary. And in fact, the Supreme Court, bestowed responsibility on this court to ensure that this is done.
Which portion did you read out?
Now, this is division bench judgment, paragraph 363. 363.
363 division.
Right.
bench judgment.
Roman III.
All right.
কোনো অনুমতি দেয় না তো বুঝতেই পারবে না তো আমি চেষ্টা বলছি
Yes. Item 27.
So far as my case is concerned, the petitioner said the challenge is only restricted to
Commission
award of,
item 27. Item 27.
award of 10 marks for prior teaching experience. That is the only challenge which has been thrown to the rules. But I will be adopting holistically. Mr. Bhattacharya has already submitted. I'll be adopting his submissions only, my lord, with the rider that the petitioners here in my lord, they do not want stalling of the entire selection process. They intend to have the selection process based on 90 marks because this 10 marks, this is, my lord, first of all, this is...
Are you all freshers?
We are freshers, yes. We are freshers. Our case is, my lord, that...
So
the
this case has been highlighted and your prayer has also been
It's
submitted.
only, my lord, a few additions. I'll just analyze, my lord, the rules, my lord. Rule 3 of, my lord, the 2025 rules that prescribes the minimum age to be 21 years. So, my lord, granting entry to applicants who are 21 years old and thereafter a rider that you have to, if you have 10 years, you'll get 10 marks for teaching experience. That is absolutely absurd. So this is one. This is basically, my lord, nothing but a sanctimonious approach and attempted sanctimony to show to the society at large that this is a transparent selection process. But actually, this process is intended to benefit a particular class. So there is no intelligible differential, and this is hit by, my lord, Articles 14 and 16, my lord. Then comes, my lord, the basis of selection, Rule 6, my lord, kindly marks. The only basis of selection is merit. But they are indirectly, my lord, clubbing it with seniority. It's merit comes seniority because someone who has 10 years of teaching experience, he cannot be 21 years old. He will be minimum 31. And he will be getting that benefit. So it is restricted to a particular class.
Yes.
And third is, my lord, this prior teaching experience. They have my lord, earmarked 10 marks for it. My lord will find it at page 42 of my petition. That's the schedule, the second schedule. There is no provision, my lord, in the forms also for indicating prior teaching experience. So this is nothing but an afterthought.
There is no provision in the form.
No, there is no provision. I did not find form provision.
Submission is that only if you fill up the form, then only the same is reflected.
Forms have to be submitted online.
Yes.
Yes. And no, how many years duration, that is not there in the form, as far as I found out.
Experience is there.
In any event, my lord, leaving that point, my lord, if we take, my lord, the notification, page 46, it speaks about, my lord, not only the vacancies existing as on that day, but also, my lord, the fresh vacancies, my lord, that may be notified. So they are clubbing everything together and eliminating competition by incorporating this 10 years, my lord, this 10 marks for teaching experience. This is, my lord, hitting directly on the principles of equality, my lord, as envisaged under Article 14 of the Constitution of India. as well as, my lord, it's also defying the rules. Because rule 3, my lord, is a stumbling block, as well as, my lord, the basis of selection, my lord, that is rule 6. Manner of selection. Selection shall be made category-wise on the basis of merit in the manner specified. So if merit is the criteria, you cannot obfuscate the issue by incorporating a teaching experience and earmarking extra marks. They are already TET qualified. Now, the Honorable Supreme Court very recently, my lord, insofar as, my lord, the outgoing teachers are concerned, who are about to retire, the Honorable Supreme Court has laid down that no, you have to do a bridge course insofar as TET is concerned. It's teacher. The TET is earmarked to be, my lord, a test ascertaining the standard of teaching of a teacher. But this will be like a double jeopardy to benefit a particular class, singling out, my lord, the mass in general, my lord, who are participating. So these are, my lord, my submissions, my lord. The prayer is restricted to, my lord, having the test at 90 marks, my lord.
10 marks, yes. And there are others also.
Because of that, my lord, item number 18. Item number 18 and 19, my lord. That 19.
1 minute.
Man, I am
1 minute.
item number 19.
কোত্থেকে শুরু হলো আমাদের?
18.
All right, 19, yes.
19 is mine, my lord.
Yes.
The 19, who are they, my lord? The petitioner, they are the participant of 2016 selection process.
19.
19.
19 क्या है?
Okay. 18. এটা হচ্ছে 27. এটা 27 কে আলাদা রাখুন আর 19 টা দিন। Yes. Item 19.
Yes, my lord. Who are they, my lord? First, I expose the who are they, my lord? All the petitioner, they are the 2016 participant candidate. And they are the wait-listed candidates, who are the actual sufferer. First time, my lord, why they become the sufferer? The act of the state government as well as the SSC and board, due to their executive work, we are the sufferer, first time sufferer. Now, my lord, after this suffering, the apex court, my lord, give the judgment, and judgment already placed and vividly placed. There is no such mentioning the who are the beneficiary of 2016 give the extra weightage. We are the actual sufferer. We are the wait-listed candidate. Due to governmental corruption, we did not get the job. Now the second time we again appear, we get 100% marks. Again sufferer. Why? First time due to their executive work. Second time due to their legislative work. Subordinate legislation. So governmental intention. What is the governmental intention? First time, these three Article 12 authorities.
No, you participated in the 2025 also.
Yes.
But then the 10 mark is troubling you.
Yes, that's the troubling
All right,
point.
so 10 marks have been argued.
Yes, that's my point. Why I challenge
All right.
it. So that is the reason. So first time we suffer due to their executive work.
All right.
And second day,
Next.
Item
Acha, 1 minute. Take down an order in item 18.
18 and 25.
Are submissions made on behalf of the petitioners. Stuff. The recruitment rules, 2025, pursuant to which the ongoing selection process is being conducted is challenged. The applications have been filed seeking addition of party stuff. As any order passed in the instant writ petition may have cascading effect on the others, accordingly, the applicants be added as party respondents in the instant writ petition. The department is directed to make the necessary amendment in the cause title of the writ petition. It will be open for the applicants to file affidavit in opposition to the writ petition. Stop. The petitioners would be entitled to file a reply thereto. Stop. List the matter for further consideration on 1st December.
But 18 and 25. 18 and 25. 18 and 25.
No, no.
18 and 25.
25.
27.
My lord, if the as submitted by my learned sector, the rule is after my lord, then it will be after interview and
The stage. It is the stage at which the 10 marks is to be given.
and my lord, the 2016 candidates are not entitled to the marks because the entire selection was declared null and void.
That's our contention.
And my lord,
That is in the first matter also.
my lord, another thing, my lord, probably your lordship was referring to item number 18, that addition of party subject to correction,
It
the
would-
addition of party applications in subsequent matters, not
My item number 27.
18, there is an
Yes,
application I can.
18 is there is also application as well as 27. There are several applications.
I'll come one by one. 25 was taken up. That is
18 and 25 has been argued by Mr. Bhattacharya. That is what we have taken note.
25. এই অর্ডারটা 18 and 25 appearances will change. Petitioner's appearance will change. Mr. Bhattacharya remains.
My number is all the matter Mr. Bhattacharya appear. 18, 90 already I handed over. Last occasion Mr. Bhattacharya appear in Bhim Shorka matter. 27. I just give the number one after another because
1 minute, they should also know.
yes. Bhim,
19 also argued.
yes.
তাহলে 19 টাও দেবেন লিস্টে।
Malad, I just give the number 18, 19, 27.
18 1 minute, one by one. 19
19, then
same
27.
order will go down.
Yes.
1 minute, 19 এ there is no application. There is no লিস্টটা দেখবেন কিন্তু application নেই 19 এ। All right, 20 20, who's there in 20? Yes, is it not related to? I'll take it up. Wait. 21. Is it SSC matter? Separate matter. Please wait. Just wait. 22. Not the same matter. 23. Same. Application is there. You are for the petitioner. Same order will go down.
I have agitated another point.
What is the point?
Some of the candidates were appointed even after the expiration of the panel. They have not come under,
Expiry of the panel.
yes, they have come under as untainted and they are set for the exam.
All right. 23. 23 application allowed. একটা line 23 তে add up করবেন। সেটা হচ্ছে the petitioners apart from the challenge to the virus of the 2025 recruitment rules, the petitioners have also challenged the action of the commission in not publishing the list of candidates who were appointed in the 2016 recruitment process after expiry of the panel.
Malad, that is also that is mentioned.
Kept on 10 December.
The commission is directed to publish the list of candidates who were appointed in the 2016 recruitment process after expiry of the panel. ঠিক আছে? Release the matter on 10th of December. It's fixed on 10th, you say? 10th.
Remember all these matters.
10th.
Item 23. Hey, one observation go down, Lordship. That is the panel of class 9-10. It had expired on 12th.
Oh, it is there. It is earlier order, it's there.
And also,
It is his matter. Let him say yes.
this indication be there in the order.
The dates?
Expired, yes, Lordship.
Dates when it expired? Give the dates. Please, নিয়ে নিন তো একটু।
12th March 2019 for
The
class 11.
the date of expiry of the panel in respect of classes 9 and 10 is
12th March 2019.
12th March 2019, and the expiry date for the panel in respect of classes 11 and 12 is
27th November 2018.
27th November 2018. All right.
I'm led by Mr. Bhattacharya and Mr.
You are?
Led by
Put it down. It is not possible for the court to memorize. A slip should be there, so it will be tagged in the file and the appearances will be recorded.
Elections made by a lordship was to give the list of the persons who have been appointed after the date of expiry of the package. Because lordship has not yet decided that we are.
Yes, this is what has been directed. All right. Yes. How does it matter whether it is published or not? Yes.
Lordship finds ultimately we are not able to persuade your lordship that we are not tainted at all.
Yes.
Once there are societal issues, we will not be able to defeat that.
আচ্ছা ঠিক আছে, পাবলিকেশনের জায়গায় প্রোডাকশন, যেখানে বললাম না যে পাবলিকেশন অফ দি প্যানেল, ওটাকে প্রোডাকশন বিফোর দি কোর্ট।
প্রোডাকশন
হ্যাঁ কোর্টের কাছে পাবলিশ।
You were submitting something. Is it in respect of this? Is incorrect?
no, not incorrect.
Only one recording, madam. This is according to the petitioner because the Supreme Court by the SSC has filed a report with the maximum going on, madam. They are taking the different date of
item 23 ki naam?
All right, this is the petitioner's submission.
Item 23, Kiran Dev Sharma.
According to the petitioner, the date of expiry of panel is such and such. This is 23. All applications are allowed.
Lordship, as
তুই
per
কি
the
জানতে নি? আমি বোঝার চেষ্টা করছিলাম।
Malad,
অর্ডার আপলোড করেছে কিনা
ঠিক আছে?
Malad, in the earlier matters, it was ordered, it was directed to be published. So should we, yes, Malad, the ones that have been kept on the 10th of December, it's not uploaded yet, but
let us see the order.
it was to be published. Yes, we have been directed to publish.
That's a different thing. I'm saying that is the expiry of panel.
Expiry panel only, sir.
No. Commission was directed to produce the list subject to correction of the Janet Senior.
I'll check up my order.
Commission was directed to produce the list, not publish the list.
Intention was to publish the Weimar sheet and say that
Something else.
OMR was published. OMR published.
Produce হয়ে গেল. Now he's telling.
All right. 24.
24 is fine, madam.
My junior told me a different.
Oh, 24th is fixed on Monday. 25 order recorded. All right. 26. Yes, please come forward.
24th কি হলো?
25 is going down with 18.
মানে 25 এর সঙ্গে
Yes.
Rahul Mandal, I don't have.
one thing in 25, my lord, I am not challenging the virus of the rule.
আচ্ছা 25 এ তাহলে ভাইরাস অফ দি রুল চ্যালেঞ্জ হয়নি।
Okay.
ঠিক আছে, 25 এ অর্ডার লিখুন যে the matter is
Same. Rahul Mandal is also same.
possibly in the last day's order it has been recorded
But
what the
mark
challenge is.
eligibility added.
Yes. That is recorded in the last day's order.
But
So I'm
the
not
real
repeating.
minor is
Lordship is
what
not
day?
required.
Yes,
25
the
related
stage.
to what
Yes.
day?
26.
Her
Rahul
submission made on
Mandal.
behalf of the
The same. When will have?
release for
Experience
further
last
consideration on first.
25.
Yes.
There is no
25, 26.
application. Application নেই, শুধু এইটুকুনি অর্ডার হবে।
26 challenged, same order. My application also. So same
18
as 18. Yes.
virus challenge. Acha, same order as 18 will go down in 26. Your no application I see. Can
Yes. All these matters.
26 there is no can.
Yes, but there are applications. There.
When did you file?
It was there, my lord.
5.
Yes, it was hard. My learned friend was there also.
This is Rahul Mondal.
Yes, this is Rahul.
ক্যান গুলো কিন্তু লিস্টে নেই, চেক করে নিন একটুখানি ক্যান আছে কিনা। In case there are applications, please file, make it ready.
Yes.
The list does not reflect the can today,
My lord,
so
some
the
of-
orders are not there. You make yourself ready
do that.
and similar orders will be passed.
Correct.
যদি ক্যান থাকে, অনিমেষ বাবু, যদি ক্যান থাকে
একটু তুমি গ্রুপ দেখো না।
সেগুলো কিন্তু ওনাকে জানাবেন,
কত আছে?
ঠিক আছে?
27
যদি ক্যান না থাকে ক্যানের কোনো অর্ডার দেবেন না। 27
yes.
27 can is there.
এই যে এটা নিন তো ক্যান
Cans allowed. না, জিজ্ঞেস করি, will it be same as 18? Why is challenge?
I am the addition. I file addition of party, my lord.
Who is the petitioner? 27.
Bindodal Bhattacharya appeared, right?
Below the sir also. Oh, 27 have. Ha.
There, my lord, 10 marks challenge is there, virus challenge is there, led by Mr.
29
Bhattacharya.
All right.
আছে না?
Same as 18. 18 মতন হবে, all cans allowed.
29
28.
My lord, 28, my lord, the matter relates to whether part-time teacher are entitled to those days.
No.
28
The ones that in the morning are adjourned for
And
another
previously,
day.
your lordship has
This has not been argued at all.
28 এর নাম কি?
Shongita Das.
Today it has not been argued, so I'll post it later on.
my lord, on 2nd.
সেটাই তো বলছি 29
Second. Main is if the it is
Sitting in item 26, Rahul, where the can is not being shown, earlier order,
can is there.
an order was passed also, can was
Oh, then it is
it
there.
was just some mistake.
Okay, if the can is allowed, then there is no requirement of further
The word allowed was not allowed. It was allowed us to
make submission.
make submissions
All
as
right.
an intervener, but
But
there was
লিখে নিন তো 26 এর order যে
all the intervening
the applicants
well, Lord, you may kindly pause. My mistake in paragraph.
allowed.
So I allow all the intervening applications. Can number 1, 2, 3.
that is the reason it is not reflected.
Yes, but today there is a better
All
wording,
right,
right
ঠিক আছে।
correspondence.
আজকে শুধু অর্ডারটা লিখে নিন যে the applicants will be at liberty, যেখানে বললাম না এফিডেভিট দেওয়ার জন্য ওই প্যারাগ্রাফটা দিয়ে দিন। That is the reason it has not been reflected. আচ্ছা 27 কিন্তু সেম অর্ডার as 18 হলো। 28 টা হচ্ছে fix it later on. List the matter for further consideration on 8th of December.
My lord, item 28.
28.
Next item 29.
29.
Well, 29 to 33 has been time has been sought for by the petitioners in the morning, Millard.
On 10th.
29 to 33, 37 and
33,
38.
37 and 38.
On 10th.
কবে আসবে?
10 তারিখ।
When is it fixed?
10th, Millard.
আচ্ছা ঠিক আছে। Has order been recorded?
হ্যাঁ
আর দিল তো।
ঠিক আছে, লিস্টের নিচে লিখে দেবে 10 তারিখ। অর্ডার হয়েছে?
শামিমি তো ছিল তো।
ঠিক আছে, ভুলে গেল। দেন
শামিমি ছিল।
এইটা আমার কাছে নেই।
আচ্ছা 34, কল 34।
একটা লেডি এসে বলেছিল।
জুনিয়র এসেছিল।
হ্যাঁ লেডি একটা মহিলা এসে।
Similar to item number 8, applications are there to be allowed.
এর নাম কি?
চৈতালি মুখার্জি।
অপোজিশন হচ্ছে।
একদম 34 না, তারপরে
18 মতনই হবে। 35
35 is mine, my lord. This matter relating to, my lord, group C and D. They published a rule, my lord, 2025 regarding non-teaching staff, my lord. I have threefold prayer.
that is different. I'll not tag up with this.
That is in that rule, 5 marks is allocated as a.
I don't have this.
Yes.
Number 2 is
But
that.
the rule is different. This is for the
And the second thing is that, my lord, till date,
But I don't have
regarding group C and group D, who are the tainted ones?
all right.
And who are the tainted one in respect to the expiry of the pen? Then who are the tainted one in respect?
And date of the applications is over.
Hard.
All right.
December is the last date.
আচ্ছা ঠিক আছে, তাহলে এটা item 35. You mentioned this matter in the morning. similar order has been passed.
That is regarding my group CD, but
Group
that is,
CD
that person not get the OMR.
OMR, আচ্ছা
So that is the
এটাকে একটা কাজ করুন 35 we'll keep it on the second
second.
2 তারিখে we need this list on second
2nd.
35 commission, please take note.
My lord.
It is second.
Pardon me. Second, there is a
All right, so third
Last date.
third is the last date, you say. Monday, if after all this is over, তাহলে no order to be recorded, let it remain in the list. Same position, let it remain. And 36.
36, I am for the petitioner. This the issue is what I supporting the 10 marks, but they are not following the circular. Earlier occasion, your lordship passed the order because they are giving the double benefit. The 9-10 teachers are getting the experience marks for 11-12 schools. That is the challenge. Because there is a notification. There is the
Let it remain in the list.
Yes.
As it is.
There is the 6 can application.
Yeah, all the applications allowed. লিখতে 36 নম্বরটা লিখুন তো। The
one application 6 is they are supporting. But other
however, all applications are allowed.
Same steno আছে।
আগে যেরকম ভাবে allow করলাম সবগুলোকে, they may be adversely affected বলে বললাম applicationটা।
ডাউনলোড করে পাঠিয়ে দেব।
Yes, cascading effect সেই জন্য এটা 36 এর applications are allowed. Opposition file করবে।
But the steno is same.
List
26,
list on second.
27 আমি ওকে শেখাতে পারবো না এখন তাই এটা সম্ভব নয়।
Opposition reply file. 37.
এও নাম বলবো।
37. ও 37 38 হয়ে গেছে। 39.
39 part time teacher claiming 10 marks for
then it will go for the
adjourn to 10th December.
10th of December.
8 perhaps
আচ্ছা 8 তারিখ।
35
আমি 44 পর্যন্ত ডাকবো।
35 group 3 and
40
EWS
Monday it will appear, কিছু order লিখতে হবে না। 41
I am for the petition.
you're giving the names now.
I am my lord a candidate who had participated in the 2016 election process and have lost the job because of the my lord judgment. I am challenging the rule, the part whereof if lordship kindly takes up my lord the brief my lord once I'll be 2 minutes I'll finish.
tell me what is there.
First point is that it has been in the course of my lord submission, someone has submitted that there was no my lord specific place.
41
There was no specific my lord column in the application form from where it will be appearing as to what is the count of my lord seniority in respect. There was an application, specific application. Lordship has also fixed one matter of mine on Monday where we were not able to provide the teacher's code. So therefore, there was specifically, there is a provision, there was a provision in the my lord, website where the forms were being filled up for counting the teacher's experience. Now, my lord, in this matter, my lord, I have challenged, my lord, the part where my lord D is prior teaching experience 10 marks. Lordship has been shown that particular provision. Under that, there is a provision at the secondary level, a government or government aided or government sponsored school calculated on the basis of 2 marks of each year of service in substantive post within bracket as permanent or contractual basis. I am challenging this contractual basis because my lord teachers
This is under challenge already.
contractual.
Yes, part-time, contractual, central government, unaided, ungovernment, all.
Kindly records one order that this is my point of challenge, my lord. I'll be relying upon one judgment to substantiate that the contractual persons who have been my lord taken in through the back door are my lord, their integrity has been questioned, and say Supreme Court has said that persons who have come through backdoor because of the nepotism in appointment of contractual teachers, because there is no check and balance in the rule which says that while taking up the candidature of a contractual person, you have to go through certain measures as to you have to first see as to whether he is an illegal appointee or an irregular appointee. Illegal appointees persons who have not.
All right, this will be taken up.
This point kindly be taken.
It is there in the list. I am not recording an order. Let it remain because the arguments are going on. As and when the matters will be taken up, it will be heard. I'm not recording anything. 42. Yes.
Similar to 18 rules has been challenged.
Additionally, my lord, already it has been made that private institution who are serving
Private. Let it remain, no order recorded. 43.
43, my lord, 10 marks for Kendriya Vidyalaya teachers, my lord, by lordship.
Very well. Let it remain. 44.
Unaided school teacher.
Let it remain. No further. এবার যেগুলো পাস ওভার হয়ে গেছে একটা
My lord, kindly keep this matter.
I'll take up. Commission